A wooden chest is carried out of a Dutch prison fortress. The guards heft it, grumble about the weight, and assume it's stuffed with books because that's what it usually is. Inside, folded up in the dark, is a lawyer in his late 30s serving a life sentence. His name is Hugo Grotius. And the man being smuggled out in a box is the same man history would later credit with writing the rulebook for how nations are supposed to treat each other. Most folks figure international law is a modern invention, something cooked up after World War II by guys in gray suits at the UN. Geneva Conventions, war crimes tribunals, blue helmets, and the second half of that assumption is even more common, that it's basically a paper tiger, a set of polite suggestions the big players ignore whenever it's inconvenient. Except the oldest surviving peace treaty between two great powers is roughly 3,200 years old, carved into a temple wall in Egypt and pressed into clay in what's now Turkey. A replica of it hangs at UN headquarters in New York. So if the whole thing started in 1945, why is the founding document older than the Iron Age? Then there's the origin of freedom of the seas, the principle that no country owns the open ocean, the backbone of maritime law for 4 centuries. It didn't come from a peace conference. It came from a legal brief written for a trading corporation that had just seized a Portuguese ship loaded with treasure and needed a good reason why that wasn't piracy. And the strangest part of the whole story, the European powers who wrote most of these rules spent the exact same centuries running the largest empires in human history. They drafted laws about sovereignty while dividing up continents that already had people living on them. Somehow both things were happening in the same rooms, signed by the same hands, which means this isn't the story of rules being invented and then broken. It's one long argument, running from Bronze Age chariots to the courtroom at The Hague, about who gets to write the rules and who gets to skip them. It starts with a battle that both sides claim they won. Around 1274 BC, Egyptian forces under Ramesses II met the Hittite army at Kadesh in modern Syria. Both empires went home and carved victory monuments. Neither could finish the other off. Roughly 15 years later, and the exact dating varies depending on which chronology Egyptologists use, Ramesses and the Hittite king Hattusili III signed a treaty, not a surrender, a treaty between equals. The text survives in 2 versions, hieroglyphs on temple walls at Karnak and cuneiform tablets recovered from the Hittite capital. And it's not vague friendship talk. It covers mutual defense, a promise not to attack, and the return of political fugitives, with a clause about treating those returned fugitives humanely. That's a functioning legal instrument, drafted by 2 states with no shared court, no shared language, and no shared God to appeal to. The Romans took the idea further and made it a profession. They developed the ius gentium, the law of peoples, a body of rules for dealing with non-Romans. They had a priestly college, the feshels, responsible for the rituals of declaring war properly. War wasn't just violence. It had paperwork. Whether that paperwork ever stopped a legion from marching is another question entirely. Medieval Europe added the moral layer. Church thinkers, building on Augustine and later Thomas Aquinas, hammered out just war theory, the idea that violence required a legitimate authority, a just cause, and the right intention. The Church also tried to limit fighting outright with the peace and truce of God movements, banning combat on certain days and against certain people. Enforcement was spotty. The concept stuck. Then Europe sailed west, and the whole framework cracked. In the 1530s, a Dominican friar named Francisco de Vitoria stood up at the University of Salamanca and asked an uncomfortable question. By what right did Spain claim the Americas? His answer horrified a lot of people. He argued that indigenous peoples were the true owners of their lands, that the Pope had no authority to hand out continents, and that discovery alone gave Spain nothing. Vitoria is often called a founder of modern international law for exactly this. But historians point out the sharper edge. He also outlined conditions under which intervention could be lawful, and those arguments were absolutely usable as justification for conquest. The critique and the license came from the same pen. Which brings us back to our man in the chest, Hugo Grotius was a Dutch prodigy who got caught on the losing side of a religious and political feud and was sentenced to life imprisonment. In 1621, he escaped the fortress of Loevestein hidden in a chest. The details get embroidered in different retellings, but the escape itself is solid history. He fled to Paris and kept writing. Years earlier, he'd produced the argument that made his name. The Dutch East India Company had captured a Portuguese carrack, and Grotius was hired to justify it. The section published in 1609, as Mayor Lebiram argued, the sea couldn't be owned by anyone. Corporate legal work that became a founding principle of ocean law. In 1625, with the 30 Years' War grinding through Europe, he published his major work on the law of war and peace, an attempt to establish that even in wartime, even between states with no common ruler, obligations existed. He's routinely called the father of international law, though scholars argue that title should be shared with Vitoria, Suarez, and Gentili, who all got there first in pieces. Then came 1648 and the Peace of Westphalia, ending the 30 Years' War. Textbooks for generations called it the birth of the sovereign state system, worth flagging. A lot of modern historians think that's overstated. The treaties themselves say less about sovereignty than the legend claims. And the Westphalian system looks partly like a story later centuries told about themselves. The 1800s brought the machinery. The Congress of Vienna in 1815 built a working diplomatic order. The 1856 Declaration of Paris set rules for war at sea. In 1859, a Swiss businessman named Henry Dunant stumbled onto the aftermath of the Battle of Solferino, saw tens of thousands of wounded men left untended, and wouldn't let it go. His campaigning led to the Red Cross and the First Geneva Convention in 1864. The Hague Conferences of 1899 and 1907 produced treaties on the conduct of war and set up a permanent court of arbitration. And at the same time, the same decades, sometimes the same diplomats. The Berlin Conference of 1884 to 1885 laid down procedures for European powers claiming African territory. Formal rules, careful protocol, and not a single African ruler at the table. The law of nations applied between nations Europe, recognized as nations. Everyone else was terrain. Then the system was tested, and it failed. Twice World War I killed on an industrial scale that all the Hague paperwork barely slowed. The League of Nations, founded in 1920, was supposed to fix it, and the United States, whose president championed it, never joined. In 1928, the Kellogg-Briand Pact went further than anything before. Signatory states renounced war as an instrument of national policy. Most major powers signed. 11 years later, the largest war in history began. The response, when it came, changed the terms permanently. At Nuremberg in 1945 and 1946, Allied prosecutors put surviving Nazi leadership on trial for war crimes, crimes against humanity, and crimes against peace. Individuals, not just states, could now be held liable. The criticism was immediate and hasn't gone away. Some of those charges were being applied to conduct that hadn't been clearly criminalized when it happened. And the judges came only from the victorious powers. At the parallel Tokyo Tribunal, Justice Radhabinod Pal of India wrote a dissent, arguing the whole proceeding was the winners judging the losers. The building boom followed anyway. The UN Charter in 1945 outlawed the threat or use of force between states, with narrow exceptions. The Genocide Convention and the Universal Declaration of Human Rights in 1948. The 4 Geneva Conventions in 1949. In 1998, the Rome Statute created a permanent international criminal court, and the old problem never left. The Security Council can authorize enforcement, but 5 states hold vetoes over it. The ICC has issued arrest warrants that go unserved for years because it has no police force. Several of the world's most powerful countries have never joined it, which is why the image of that chest sticks. The man credited with giving nations a common law had no army, no throne, and no way out of his own cell except to be carried through the gate, disguised as a stack of books. His ideas traveled the same way, quietly inside somebody else's cargo, depending entirely on the people hauling the box not to look inside. International law has never had a sheriff. What it has is language. Every state that invades, annexes, blockades, or bombs now takes the trouble to explain why it was legal. 3,000 years on, empires still don't obey the rules. They just can't stop arguing that they do. If this one hit subscribe. Ancient Edict drops a new origin story every week. And drop a comment with whatever you want dug up next. We're always taking requests.